Well, hello there. How is everyone? I hope you are all well. You amazing, amazing, beautiful, wonderful people. And that's right, you are looking absolutely wonderful today. So you must be having a good weekend. My weekend has been a complete mess, which tomorrow, I've got a video ready for tomorrow, which I thought I was doing for today. This video is for today, and I thought I was... Don't ask. Live tonight, don't forget, live tonight. It's the mental health live. It's not going to be about normal crimes and stuff like that. So not everyone's going to be wanting to be involved in that, but I feel that it's very important for the community to have a chat, something a little bit different and touch on how people are. And if you do want to join us, please do. But this morning, we're talking about the other docs. I did a video yesterday, only a short one, that spoke about the prosecution basically trying to rebuff the attempts for the defense to ask for a change of venue. A lot of us feel that there should be a change of venue. It's mixed emotions. It's kind of split the room. Some people feel that it's not needed. Some people feel that it absolutely is needed. Some people are turning around and saying that you couldn't go anywhere and get a non-tainted jury pool, so what's the point? But I think that the interesting thing is that Latah County or the prosecution here are trying to say that there isn't a tainted jury. What are you talking about? That sort of argument is premature to make a decision to move because you don't know that it's going to be tainted. I argue that, but I understand that not everyone's going to feel the same way. But there was some other docs that came out at the same time, and I just want to touch on them, see how you guys felt. It's not going to be a long one, but important all the same, because again, I think it just points towards an element of control. This entire case just reeks of the prosecution controlling everything and dictating what can and can't be done and how it will be done. And if you're not happy with it, then write to us and tell us that you're not happy, and we'll consider it. And maybe that's just how the judicial system works. But to me, it's just this really uncomfortable situation when you've got somebody who is accused of doing a heinous crime that could potentially lose their life because of it. There are so many questions that even make some people with more sort of critical minds sort of ask whether he is the right guy and are not 100% convinced because they don't listen to paid media narratives. And, it's anyway, let's have a look and see what you think. So these were the docs. So that was the first one, which we did yesterday. We then had these ones, which was states' responses to defendant's motion to allow certain experts and investigators protected access to view IgG materials, and motion requesting clarification of the sealed order for disclosure of IgG information and protection order. So it comes now, State of Order Idaho, by and through the Latah County Prosecution Attorney, and respectfully submits a following response to the defendant's motion to allow certain experts and investigators protected access to view IgG materials, filed on the 1st February 2024. The defendant's motion requesting clarification of the sealed order for disclosure of IgG information and protective order, filed on February 8th, 2024. Regarding the expansion of the protection order to include Dr. Leah Larkin, Bika Barlow, and Stephen Mercer, the state does not object. Regarding the expansion of the protection order to include unnamed criminal investigators, unfettered access to the IgG material, the state objects. At a minimum, individuals who will have access to any of the IgG material should be named. Further, defense has failed to make an adequate showing as to why such individuals need the information for the preparation of the defense. Defendant states that the information is requested to investigate how and when Mr. Koberger was identified as a suspect. This information can be obtained from the TUI letter from the FBI to the state dated the 28th, 2023, November. The state objects to the balance of the IgG materials being provided to the criminal investigators for the reasons articulated by the court in its protective order. Regarding the defense's motion requesting clarification of the sealed order for disclosure of IgG information and protection order, the defense experts or investigators should not be allowed to use the protected materials to identify individuals or witness to contact without prior authorization from the court, and after showing why such contact is necessary for the preparation of the defense. So again, this is all about control. They don't want the defense to allow access to information unless the prosecution have their names, which some people are going to argue and say, well, yeah, that's fair enough, but what if Ann Taylor is fearful that this is to do with coercion? Let's not forget what happened with the IgG information early on with the FBI going after one of the professional witnesses in this situation and made her very, very quickly retract statements that she'd made. They are already seemingly in a situation where they feel that the knife sheath, for instance, could have been planted. That's the angle they're going for. And this prosecution team are basically saying, you're not to give anybody access to that unless we have their names and to show us exactly why they need to see it. This would not prohibit the defense from contacting potential witnesses learned through sources outside of the protected information. The state respectfully submits that the appropriate course of action would be for the court to amend sealed order for disclosure of IgG information and protection order to allow Dr. Leah Larkin, Bicker Barlow, and Stephen Mercer access to the IgG materials disclosed to the defense. The criminal investigators seeking access to the information should be named in the order, and those investigators should only be allowed access to the November 28, 23 letter provided to the defense, which they're obviously referring back to the TUI letter from the FBI. So that's what relevance has that got? The state also requests the following language for an amended protective order. The court orders that only defense counsel Ann Taylor, Jay Logston, and Eliza Masseth, defendant Brian Koberger, and Dr. Leah Larkin, Bicker Barlow, and Stephen Mercer may view the materials provided. Insert the names of the criminal investigators. May view the November 28th, 23 letter. So what they're basically saying here is now, even if they name the criminal investigators, they're only going to give them access to the TUI letter. Any further dissemination of the materials or the information contained within the materials must first be approved by the court after an adequate showing by the defense as to why such information is necessary and material to the preparation of the defense. Additionally, no individual learned solely through the review of the materials shall be contacted by the defense or any agent of the defense without prior authorization from the court after an adequate showing as to why such contact is necessary and material to the preparation of the defense. It's absolutely bonkers. Again, I'm a layman, so with respect of the laws, I'm not 100% on it, am I? But this is what spurned that response. So you've had the response. So this was what they asked, and this was the concerns raised. Comes now Brian C. Koberger buying through his attorneys and hereby moves the court for an order clarifying language contained in the sealed order for disclosure of IgG information and protection order filed with the court on December 29th, 2023. The court's sealed order states that no individual on the family tree may be contacted by the defense or any agent of the defense without prior authorization from the court after a showing as to why such contact is necessary and material to the preparation of the defense. The defense, as part of necessary work, has previously identified family members and work is being conducted. The defense does not expect to use the protected materials to identify people to contact without further order of the court. However, the defense needs to continue its investigation with witnesses and resources generated from sources outside of the protected materials without the worry the plain language of the protective order could be interpreted to prevent that work. The defense seeks clarification of the language, the specific language of the protective order. So did they even answer the question that was being asked of them? Or did, again, they just double down on this IgG situation and the fact that they're so hell-bent on not allowing certain people access to it unless they just don't want anybody to have access to it. And if they do allow people, they want to know exactly who it is. Just all control. It's all it feels like. Let me know down below, and I'll catch you all in the next one.